marijuana for sentencing. Whose phone is that? All phones need to be on silent or off.
I don't know what to do. November 2nd at 8:30.
Mr. Margolis, I cannot continue on the record because I cannot, well, he's not even there anymore.
I got beans, greens, potatoes, tomatoes, lamb, rams, hogs, dogs, chicken, turkeys, rabbits, you name.
The THC, I did have my card for that. Since I was released from jail, I haven't went back to smoking. I didn't submit anything in front of the judge for the use of the marijuana card. I realized I can't do anything to stay on a good path.
I don't know what that means.
I think maybe using marijuana may have led to other things. So with my card, she said I needed to submit to the judge a doctor's note to use it. I haven't done that. I've just decided not to do it, period.
Technically, because you are in violation of the Medical Marijuana Act, you're not entitled to be able to use marijuana anyway, because you had THC in your system at the time also.
Okay,
along with all the other drugs.
The woman from Community Corrections told me that as long as I had the card, I could use, and I submitted my card to her.
All right, well, I'm explaining to you that is not correct. I'm the judge and I say you can't.
Okay, I understand that. At the time, I did not.
And you're telling me that you're on the straight and narrow when just 2 months ago you were testing positive for cocaine.
From then to now. When I was released from jail, I haven't done anything. I haven't failed any tests.
Sounds to me like we're still at the same place where you don't have a full understanding of your own substance use disorder.
I do understand. That's why I know I cannot do anything. If I do Xanax, I do stupid things. I do too much. I forget. I haven't been to the doctors, got back on anything since this case came about. I do understand that I've had issues in the past, but I can tell you from here forward, I will not have any.
All right, thank you. I'm going to impose sentence at this time. It is the sentence of this court that you serve 365 days in the Washtenaw County Jail. Credit for 23 days served. The balance, 342 days, are suspended, meaning that if you do everything you're supposed to do and you follow the orders of this court, then you won't have to do any additional jail time. You must do 6 days, a total of 48 hours of community service, 18 months on probation, fines and court costs in this particular case for a total of $725, $30 per month in probation oversight fee. You must complete an assessment at community corrections and follow all recommendations and sign a release of information for the probation department. You must register for the assessment within 48 hours. You'd attend the MAD Victim Impact Panel within 45 days of sentencing and provide a certificate of completion to the probation department. You're to report to your probation officer. You'll attend the MAD Victim Impact Panel within 45 days. I think I said that. You report to probation officer monthly via online reporting platform and meet with the probation when and where directed, including any and all home visits. You're to have no use of alcohol, marijuana, illegal drugs, drug paraphernalia, weapons, firearms, firearm components, ammunition, or other dangerous weapons, and not be in the presence of anyone having or using those. You're to continue on the GPS tether. The whole excuse about not being able to work is not acceptable because they will give you out dates and out times to be able to go to work as well as to go to any dental appointments you may have. So that is not an acceptable excuse to me. You are to attend 12-step meetings 2 times per month and provide proof of attendance to the probation officer on a monthly basis. We'll do a review in this case on January 22nd, 2024 at 10 o'clock a.m. I'm going to give this number to you and to everybody else that's on the line here. If you are here and you may be going to or need to contact the probation department, please write down your phone number at this time. You have a pen, Ms. Evans?
I can grab one. Okay.
734-483-7336.
And that's probation department.
That's correct. Please call them tomorrow after 9 a.m.
Okay, can I ask what you said about within 45 days? What was that program?
The MAD Victim Impact Panel, within 45 days, they're going to go over your contract with you and give you all the information you need to know about how to reach out to the particular organizations that provide the programs that you've been ordered to complete, okay?
Okay, thank you.
You're welcome. Have a good day.
You too.
Gobble, gobble.
23S00422, 19S00714.
Rachel McDuffie for the people.
Good morning, Assistant Public Defender Davy Lebo for Ms. Sandlin. Ms. Sandlin, could you please state your name?
Brenda Sandlin,
Thank you. Good morning.
morning.
Your Honor, if we could pass this matter, I believe I did send an email to Ms. McDuffie yesterday asking if there be any offers in this matter, which I have not received a reply to yet.
Mr. Lebo, you received a reply to that email yesterday, right after you sent it to me.
Let me see if I can find that. Yes, Your Honor, we'll be asking for an adjournment as Ms. McDuffie indicated to me that she needs some time to consider any offers in this matter.
Thank you.
No objection to the adjournment. I do want to address bond, Your Honor.
You may begin.
Thank you, Your Honor. So Ms. Sandlin was recently arraigned. These are 2 cases with the exact same offense date. Somehow the previous case just kind of languished in warrant status until she was picked up on the exact same charge, which is the OWI with the occupant under 16 years later, most recently this year. So Ms. Sandlin, there's a combination of alcoholic drugs and drugs that issued. In the first case, there's an alcohol test result. In the second case, she admitted to alcohol, but it did not show up on the testing. But I have a positive ETG for her from yesterday, from community corrections.
Yes, it does show on September positive alcohol. Miss Sandlin, I need to arraign you in violation of your bond. Ma'am, you were ordered to drug and alcohol test and not have any alcohol. It appears that yesterday on September the 6th, 2023, you took an ETG test and you were positive, as well as a PBT test, and you were positive for alcohol for both. That is a violation of your bond conditions. If it is found that you are in violation, or if you admit to being in violation, you could be subjected to have your bond revoked. Do you understand that, ma'am?
Yes, I understand that, but I haven't been drinking. All I've been doing is taking my medicine. I ain't drank.
And she tested today?
Yesterday.
She needs to test today again.
Your Honor,
Yes, Ms. McDuffie.
Oh, I would appreciate that, Your Honor. I was just going to mention that I watched Miss Sandlin at her arraignment, and she did appear, and I don't know if the tendency of her slur of speech and the way she presents now is just her, but she did present that exact same way when she was arraigned. So I do appreciate the court request for another testimony.
Now, we have no objection to an additional test form, Ms. Sandlin. I would note that my understanding is that her speech is affected by the medication she is taking for some medical conditions.
Thank you. As to the bond violation, Mr. Bo.
My understanding that Ms. Sandlin does deny consuming alcohol, so she'll be pleading not guilty to that violation.
Bond hearing will be scheduled for September the 14th, 2023 at 11 a.m. in person.
And since that result was just from yesterday, is there still the opportunity to get that confirmed?
It's my understanding that there is an opportunity to do that. If you're asking that she do that, then what's going to happen is this court date can't be next week. It would need to be after the information is received.
We would request it as well, Your Honor.
All right, she needs to go and pay the $30 for the confirmation test. Any other requests with respect to the bond, Ms. McDuffie?
Your Honor, it appears that she is on ETG testing. I'm not sure exactly if the ETG was just a random test or if it's standard PBT. I would prefer that all of her tests are in the ETG format and not PBT. If that's something that can be ordered. And I just wanted to be clear that she is being asked to report today for a test, as well as I guess she's being informed that if we want to get the confirmation, she needs to do that pretty much today as well. I don't know what the time period is for the limit for requesting that confirmation.
I think it's like 36 hours or something. So yes, she should do that today. As far as Mr. Bowen, say regarding the bond request for ETG, I think it's already ordered in both cases. And I'm gonna ask for ETG and a PBT today because our ETG test will show the same results from yesterday. We need to know whether she has a PBT test positive today. She is on intermediate testing, whatever that means.
You test once a week. What? Tell them you test once a week. I test once a week.
I'm gonna have her do a PBT test today. I don't think the ETG is gonna give us much insight on today's date. Ma'am, are you local at this moment?
Say yes, Your Honor. Yes, you are.
I'm gonna have you go test within the next 2 hours, okay?
Okay.
I'm gonna continue the ETG testing 1 time per week.
And keep dropping.
Are there any other substances involved or only alcohol? I think you did mention that there were other substances
Yes, Your Honor. And there was THC. I know THC was detected in the first case as well. Ms. Sandlin, as her counsel mentioned, is on a number of medications for some other issues. So the substances in her second one, I would have to refer to the complaint for exactly what those are. But essentially, with respect to the charge, they would be things that are known to exacerbate or cause drowsiness, especially when combined with anything else. So I think THC is in both.
I see. All right, it looks like the next available date after, if we're sending this for confirmation, is really 9th to October 12th for the hearing. Ma'am, if you have another positive alcohol test, the ETG test, then I'm gonna have to have you picked up. Do you understand that?
Yep. Yes, Your Honor. Yes, Your Honor.
October 12th, 2024 at 11 a.m. in person for the hearing.
Okay, thank you. Oh, good. Thank you.
Thank you. You're all set. Have a good day.
All right, you too. Damn, rehydrate fast. Like a drop on.
And then after the Hoyos, we'll take up your case, Mr. Bauer. Sure. All right, the court is calling 2020 CR 7006, State of Texas versus Brandon De Hoyos. Could I have parties announced for the record for the state?
Debbie Cruz on behalf of the state, Your Honor.
For the defense?
Kathy Compton for Mr. De Hoyos.
All right, and are you Mr. De Hoyos?
No.
Your attorney is by Zoom. Any objections to your attorney appearing by Zoom?
No.
State any objections? All right, so this is a continuation of the hearing from February 16th. So Mr. De Hoyos, I'm going to give you a choice because felony drug court does not want you back. And you know why they don't want you back. So your little trips to Crystal City, and you know what that's about. So this is what's going to happen here. I can continue on probation, but you're not doing SATF. You're going to be doing SafeP. And once you get out of SafeP, I'm going to run my little drug court here. And you know what's going to end up happening? Once you're out of SafeP, you're going to report to this court every single day until further notice. So Monday, Tuesday, Wednesday, Thursday, Friday. If it's not a holiday, you're coming in to report.
Yes, ma'am.
Or I can revoke you and you can be sentenced up to 5 years in prison. So which would you prefer?
You said safety?
Yes.
Yes, ma'am.
All right. Here's the thing. Sometimes people you just can't help them because they don't want to help themselves. Have you ever heard of the song Harry Hippie?
No, ma'am.
That's one of my favorite songs by Bobby Womack. You know what some of the lyrics in it are?
No, I do not.
You have this guy named Harry Hippie. Everybody's trying to help him. They try to, and the lyrics go that, they try to help him, his old lady and his children, and they try to help Harry. But you know the thing about Harry Hippie? In the lyrics, it says, how can you help a man who wants to be on the ground? So if you want to be on the ground and won't accept any help and you won't follow through, then there's no help for you. You need to just go to prison and do your time.
Yes, ma'am.
So this will be your help. And I am not going to be considering things like, oh, this is my relative or this is that. That doesn't work in this court. Your relative can be the president of the United States. In this court, everybody's treated the same.
Yes, ma'am.
You could be the most wealthiest person in the world. You could be a billionaire. Doesn't matter in this court. Do you understand?
Yes, ma'am.
So you are going to shape up.
I will. I promise you. I'm tired of living.
Don't do that. Don't make any promises that you have no intention of keeping. You need to show actions. You've been on probation out of this court since 2020. And so far, the only thing you have done is fail miserably. And you fail miserably because you just want to do what you want to do. Maybe you just want to continue to use drugs. I don't know. But you've been behaving as you do because I know felony drug court is a very good program.
Yes, I was hoping they would take me back.
No, they don't want you back. You failed miserably. And so you're going to have to start doing better. And when somebody gives you tools to help you stop using drugs, your choice is Either you use those tools or you do not. Do you understand?
Yes, ma'am.
All right, so this is what the court is going to do. I'll deny the motion. Probation and state are asking the court to deny the motion. Going to alternate amend conditions. You need to take off that hat to include, he's going to go to safety and he's to remain in custody until accepted. Upon successful completion of safety, he's going to report to the 187 District Court Monday through Friday until further notice. He's going to be on a GPS upon release. And he is not to leave Bear County. And of
Judge,
course,
would,
that
I'm
not leaving Bear County is after Safe P, because I know Safe P is not in Bear County. Yes, counsel?
I'm sorry, Judge, I didn't mean to interrupt, but I did want to ask you if you could just clarify for the GPS that the fees for the GPS would be waived, because those are very pricey and he is at this point indigent and probably will be for a little bit at least while he gets his feet back under him when he gets out of safety.
All right, I'll ask that fees be waived or deferred. And he's going to have employment within 30 days of release from custody. No employment as a home health care provider with minors. And he's going to do the UA hotline until further notice. And probation, I'm going to want field visits upon release 2 times per month until further notice.
Your Honor, would the court consider waiving his requirement to report daily to the courtroom once he provides the court with verification of an employment of a job that he
No.
has? Okay.
No, because if he was in felony drug court, he would be reporting daily.
I'll just report on Thursdays.
Well, you're reporting daily in this court because then obviously that didn't work for you.
100%.
How old are you?
29.
So you're 29 years old. So you are going to be in this court every single day. If you miss reporting to this court Monday, Tuesday, Wednesday, Thursday, or Friday, a motion to revoke is going to be filed.
Yes, ma'am.
If you leave Bear County, even if you just dipped your toe across a different county line, a motion to revoke is going to be filed. You understand?
Yes, ma'am.
So Judge, I'm sorry, I just want to clarify for him, so there's no question. Does he need to report at a certain time each day, or will he
9
have
a.m.
a window? Okay.
9 a.m.
So, ma'am, if I get a job, I have to let them know I have to report every day.
9 a.m.
9 a.m.
Mm-hmm. Is there anything else?
Do you know which safety I'll be going to?
No, I do not. But I do know you would not be going to safety if you would have done what you're supposed to do. You would have been in felony drug court, maybe successfully completing it. I know that when I placed you on probation in 2020, you probably would have been done, but a motion to revoke was filed. So then you got sent to safety in 2021.
Saturday. I went Saturday.
No, you're going to safety.
Oh, I thought you said I was sent to.
No. Anything else?
No, ma'am.
All right, and there's to be absolutely no Crystal City for him. So nobody come to me with a motion asking if he can visit relatives in Crystal City.
So my
That's
son
no.
is-
No, you're not going there. I know what issues have been occurring in Crystal City, so you're not allowed to go there. And do not play games to me and pretend like you don't know. You are not allowed to go to Crystal City. You're not allowed to leave Bear County. Do you understand?
Yes, ma'am.
All right, is there anything else?
Nothing further to have a say on.
Anything else?
You know how many
No, Your
days-
Honor, thank you.
How many months I'll be attending?
You really don't want safety. See, this is what ends up happening. Everybody comes before me sometimes when they have a drug issue and they're not ready to address it. What ends up happening is they try to write their own program. I'm going to tell you this. You're going to wait for your transfer to safety. Safety is a 6-month to 9-month program. Then when you get out, you're going to have 3 months of aftercare.
Yes, ma'am. That's fine.
Anything else? Any other questions?
No, ma'am.
All right, you can always choose to go to prison for 5 years. It's completely up to you.
Yes, ma'am.
Anything else? Counsel, anything else?
No, Your Honor. Thank you. Can I be excused?
Yes, you may be excused.
Thank you for letting me zoom in. I appreciate it.
Oh, you're welcome.
Five.
The 14A District Court is now back in session. All those having business before the court draw near, the Honorable Judge James Cedric Simpson presiding.
And good morning. Just called case of, is it Tanyi Agbor? Is it Bayi? Versus Standard Auto Service.
Good morning, Your Honor. Carl, for the defendant.
Your name,
Good
sir?
morning, Judge. Kanye Agbobayi.
Are you driving?
I am almost parking, sir. I'm almost parking. I got to pick my daughter.
You need to
from
pull
school.
over.
Yes, Judge. Yes, Judge. Judge, if you can give me 4 minutes, I'll get to the school.
No, I'm not giving you 4 minutes. This is the time for your
Okay,
thing. You
Judge.
need to pull over.
I pulled over, Judge.
All right. This case. Counsel? Anybody want to tell me where we are on this case?
Carl Scheer, Your Honor. Case was before Judge Barr. My client had had a matter with the city of Ypsilanti at a time when Mr. Barr was counsel for the city, and he recused himself.
Right.
Excuse me.
I got all that. I think the issue in this case is there was an engine put into a vehicle, right?
Yes.
It lasted 8 months. And then the question is, who's responsible for the failure of the engine?
I think that's correct.
Sir, is that a correct statement of what's going on here?
That's a correct statement, Judge.
Okay, so I also understand, and are the parties in agreement that there was a 90-day warranty on this engine?
Yes.
I don't remember about that, Judge. I don't remember about any 90 days.
All right,
And
so
before we move on, Judge, I know before Judge Barr last January, the defendant judge supposed to call me for us to negotiate. He never did that, and now it's like we are starting over. It's like they're buying time for something.
you're breaking up, sir.
Judge Barr had. Yeah, Judge Barr had given him the opportunity to settle the case with me. I'm not sure why he did not do that. And now it's like we are starting over. And this keeps coming. I just don't understand why we have to go through this.
Well, you filed a lawsuit. That's why we have to go through it.
Okay, Judge.
I mean, the problem is that if there's a 90-day warranty on the engine, what are you saying happened to the engine, sir?
Judge, what happened to the engine? First of all, there are two brothers. There are two brothers who work in that location. The mechanic shop. One was Musa. I negotiated everything with Musa before he started the job. I brought all of this on the table. He told me that, don't worry, Tanyi. Be aware, Judge, I've been a loyal customer to these guys for almost 23 years. I've been loyal to them. He told me that don't worry about it. As long as you do your oil changes, you'll be fine. I said, okay, Musa, I trust you. And so in 3 months, I came back to do my oil change. When the car had a problem after 8 months, I came back. The brother had just come back from vacation within that 8 months. The allegation was that I drove the car above 5,000 miles. You know, and I'm saying, how does that correlate with the whole situation? How does that correlate with the engine of the car? So that was my problem. I said, it's not fair. I said, we are in America. At least, there is warranty. It's the law for you to install a part on my car and let me know and give me some warranty time. The brother must have said it was not a problem. There wasn't any 3 month agreement, sir.
So when did you're saying you did an oil change there?
I did an oil change there. So I took the car they gave me the car in I think February of 22, February of 21. I came back, I did my oil change in April. They have the record. And then they're saying that I drove for 5,000 miles. He was saying all this without knowing all the Mo. His name is Mo. He's the one that was in his country and came back, and then I met him. He's the one that, just because on the defense, that I drove 1,000 miles. I called Toyota. Toyota said that shouldn't be a problem.
And Mr. Chair, I guess from your client's perspective, he's not saying that he's saying that they didn't do an oil change. Mr. Scheer, you're muted, sir.
I'm sorry, I was coughing.
Okay.
But I didn't want to cough while this was going on. I apologize.
No, it's okay. It's okay. But from what I understand plaintiff saying is that he did an oil change, that he did it at your client's establishment. When I read your answer, you guys are claiming that he didn't do an oil change at all.
That's correct. If he did an oil change, it would show up in our records.
Judge, I did an oil change. In April.
Okay, all right. Do you have the receipt for the oil change?
I'll look for the receipt, Judge. I think I had submitted that receipt there.
Say again?
It should be in the file there somewhere.
Well, they're saying that their records don't show that you came in for an oil change. I'm asking, do you have proof that you went in for an oil change?
I don't have proof of that, sir, but the money that I paid them is on my bank account. It's on my bank note that I paid for the oil change.
All right. Here's what I'm going to do, because, I understand what the issues are. And is there any information, sir, that you need from the defendants in this case?
And Judge, just to let you know, they've impounded my car without my.
No. I just need to know, is there any information, documents or other things that you need from the other side? Sir? Man.
Judge, I will send him copies of everything I have.
All right.
But I'll do it again.
Mr. Abor Bay?
Yes, Judge.
They're going to send you everything that they have. Mr. Scheer, is there anything that you need from him?
His car, I need the disposition of the car. My understanding is it was towed. And if he has any documents relating to the disposition of the car, I need those.
Sir,
Mr. Shaw, what do you
what
mean by
happened to
the
the, what
dislocation?
happened to the vehicle?
Your Honor, I had taken the car there hoping that we will negotiate for us to come up with a deal, an agreement for me to at least pay something for them to at least get the car running. So to my greatest dismay, I went back there to get my car. They said that my car was stolen. You know, I said, why should you guys impound my car without my knowledge?
So you don't know where the car is?
Judge, I did my research and I think it ended up in Stadium Towing. I went to Stadium Towing. I had a conversation with Mr. Sher. He said that he was going to talk to them. Till today, he hasn't mentioned anything about it, and my car has been salvaged.
Okay, here's what I'm going to do. I'm going to set a final settlement conference in this case for September 15th, 2023, 9 a.m. At 9 a.m. I'm sorry, that's at 3:30 p.m. That is in person. That means you got to come here. I need the plaintiff here, certainly that you have to be here. And Mr. Sherry, you'll have to have somebody that has authority to settle the case. If we can't get it settled on that date, I'll set it for trial.
All right, again, September 15th at,
At 3:30, September 15th, 3:30.
thank you.
Yes, Judge.
All right? All right, thank you.
Thank you, Judge. Thank you, Judge.